As Alberta businesses reopen, some as early as today, employees and employers have a lot of questions about their rights and responsibilities. To help answer them, we're joined by employment lawyer Lior Samfiru from Toronto. Lior, thanks for making time. Why don't we just start with a big one? Do employees have to return to work if that workplace reopens?
And that is probably the most common question that I've been asked now. So here's how that works. Employers have a very strict duty to abide by all government measures in terms of safety, in terms of reopening their business, social distancing, etc. Now, once the employer does meet these requirements, an employee is expected to go back to work. Even though the employee may still feel unsafe or uncomfortable, the employee is expected to go back to work. And the concern here is that if the employee does not return back to work, they may be considered to have resigned, which means they lost their jobs, and then can also be disqualified, of course, from government benefits like the CERB. Now, the exception is if you have a doctor's note that says that you're sick, that you should not be working because your immunity system is compromised, that may be fine. But for most employees, Jennifer, they do have to go back to work.
Let's talk about some particular scenarios. What if, for example, a person can't secure childcare?
So some schools, some areas have now started opening schools and daycares, but for those individuals that cannot secure childcare, they are allowed to stay home. There have been amendments that the Alberta government has instituted to allow parents who have school-age children to stay off work and without penalty with job security. So if your school, your child's school is not open, there's no childcare, you can remain indefinitely off without penalty and continue receiving government benefits.
Now, you touched on it briefly, employer responsibilities, but what if a particular employee, say, has health concerns, say they live with someone who's immunocompromised or they are themselves?
Yeah, unfortunately, there's no easy solution to living with someone that may be compromised. If you do have yourself a medical condition, get a doctor's note. If the doctor agrees that you should be off work, that gives you protection. Your employer cannot let you go and must allow you to stay home, and then you're fine. Now, for employees that have other concerns, family members, etc., the best advice is speak to your employer. I think a lot of employers are understanding and reasonable and maybe will work with the employee to allow them to work from home or perhaps to delay their return from work, but you must have that conversation with your employer.
And on that, on employers, what are they able to do? Can they change the terms of someone's work, their pay, their hours, their schedule, that kind of thing?
The general rule is that an employer does not have a right to make significant changes to terms of employment. A lot of employers are bringing back people with lesser pay. The reality is that that's actually not allowed. At least what that means is it gives the employee the right to treat those changes as a termination of employment. We call that a constructive dismissal. So if you're in that situation, you can accept the change and continue working, or you can treat that as a termination and require your employer to pay severance. If you are going to accept the change, my best advice is let your employer know that you do expect your terms of employment to resume once this COVID virus hopefully is behind us.
And let's say something goes wrong, or you're presumed to have resigned. It's one of those situations, and I know we have unionized employees, non-unionized employees, federally regulated, provincially regulated. But what would, say, the next step be if there's a disagreement in terms? Do you have to sue your employer? Is that sort of your recourse?
Well, you hope to always avoid any legal dispute, and you avoid it by having good communication with your employer and hopefully coming to terms that everyone can live with. But in situations where an employer is being unreasonable, doesn't accommodate an employee, deems the employee to have resigned when they really have not, then yes, there is a possibility to commence legal action or even filing a claim with the Ministry of Labor. But certainly that's something employees always wish to avoid, and communication really is the key.
Yeah, a lot of questions, so thanks for helping us answer some of those today. Lior Samfiru, thanks so much.
Thank you.